Hey everyone, and welcome. Today we are diving deep into a question that's right at the heart of business law. It's something that can literally mean the difference between a smooth deal and a total disaster. And that question is, when does property actually transfer from a seller to a buyer? Now it sounds simple, doesn't it? But in today's world of online shopping, pre-order, and crazy supply chains, the answer is more important and honestly more complicated than you might think. All right, let's get into it.
Okay, just imagine this for a second. You finally did it. You bought your dream guitar. You've paid for it, you've got the receipt in your inbox, and you're all set to go pick it up from the shop tomorrow. But then, overnight, the unthinkable happens. A fire breaks out, the store is gutted, and your brand new guitar is destroyed. So who's out the money? Is it the shop, or is it you? The answer to that question all comes down to the precise legal moment that ownership, the property in that guitar, passed from them to you. And that is why this stuff is so incredibly important.
So let's be super clear on what we're talking about here. When we say transfer of property, we are not talking about the physical handover. Nope. We're talking about the transfer of title, of all the legal rights that make something officially yours. You can own something you've never even seen, and you can be holding something that you don't legally own at all. Getting this distinction down is the absolute key to understanding everything else we're going to cover.
So, here's the game plan to make sure you've got this all locked down, especially for your exams. First, we're going to nail down that difference between property and possession. Then, we'll get into the golden rule of risk. After that, we'll break down the rules for specific, identifiable goods versus goods that are just part of a bigger pile. And finally, we'll tackle the really interesting NEMO-DAT rule and its absolutely critical exceptions.
Right. Let's kick things off with the absolute foundation of this entire topic. Seriously, if you get this next part, everything else just clicks into place. We're talking about the huge legal difference between owning something and just, well, having it.
So, look at this. On the left, property is all about ownership. It's the ultimate legal right. Think of it like your name is on the title for a car. But on the right, possession is just about physical control. It's having the car keys in your hand. You can rent a car, right? You have possession, but the rental company has the property. And here's the flip side, which is so important for online shopping. You could buy a new phone online. The second you click confirm, the property, the ownership, might legally become yours. But the phone itself is still in a warehouse somewhere, so the seller still has possession. See the difference? Okay, now that we've pulled those two ideas apart, let's connect property to risk. This next bit is the principle that directly answers our burning guitar shop question. It is, without a doubt, the single most important rule in this whole area of law, so you're going to want to remember this one.
The whole idea is captured in this old-school Latin legal maxim, res paret domino. Yeah, it sounds a little intimidating, but its meaning is actually super direct and powerful, and it has shaped business law for hundreds of years.
And there it is. Res paret domino just means the risk passes with the property. Simple as that. In other words, whoever's the legal owner of the goods at the exact moment they get destroyed is the one who takes the financial hit. It doesn't matter who's holding them. It doesn't matter if you've paid yet. The only question the law asks is, at the moment the fire started, who was the legal owner?
And this isn't just theory, right? Pinpointing that moment of ownership has huge real-world consequences. First, obviously, is the risk of loss, like we've seen. Second, only the legal owner can sue a third party. So if a courier smashes your new TV, you can only sue them if you officially owned it when the van crashed. And third, this one's a biggie, insolvency. If you pay a company to build you something and they go bankrupt, whether you get that item or just get in a long line with other creditors depends entirely on whether the property had already legally passed to you.
Okay, so we know that finding that exact moment of transfer is everything. But how do we actually do it? Well, let's start with what we call specific goods. That means goods that are identified and agreed on when you make the deal. You know, that one specific car in the lot, that one painting on the gallery wall, or our one-of-a-kind guitar.
This flowchart is basically our guide. And notice the very first thing at the top. The law always, always, always looks to the intention of the people involved. If you and the seller agree in the contract, in an email, whatever, that ownership passes when you pay or when it's delivered, well, that's what the law will follow. Intention is king.
But let's be honest, most of the time nobody actually says when they intend for property to pass, so the law gives us these default rules. Rule 1 is the big shocker. If the goods are specific and ready to go in a deliverable state, property passes the instant the contract is made. Yeah, you heard that right. Before payment, before delivery. So for our guitar, if it was just hanging on the wall, ready to go, you legally owned it and took on the risk of the fire the second you agreed to buy it. Rule 2. If the seller has to do something first, like polish it, property only passes when the work is done and you've been told it's done. Both things have to happen. Rule 3 is similar. If they have to weigh or measure something to get the price, property passes when that's done and you're notified. And finally, Rule 4. For stuff you take on approval or sale or return, property passes when you say you want it or if you just keep it past the agreed-upon time.
And here's a classic case that shows Rule 4 perfectly. So, a horse was sent to a potential buyer for an 8-day trial. A classic sale or return deal, but on the 3rd day the horse died, and it wasn't the buyer's fault. The seller sued for the price, saying the sale was done. But the court said no, the loss is on the seller. Why? Because the 8-day approval window hadn't closed yet. The buyer hadn't officially accepted it. So ownership, and with it, the risk, was still with the seller.
All right, let's switch gears. What happens when you're not buying one specific thing, but something that comes out of a larger pile? Think like 50 tons of grain from a silo that holds 1,000 tons, or 100 gallons of fuel from a giant storage tank. We call these unascertained goods, and as you can guess, the rules have to be different.
So for these goods, there's one absolute non-negotiable rule. Property cannot pass until the goods are ascertained. And that's just common sense, right? You can't own some of the grain in a silo. You can only own the specific 50 tons that have been separated out and marked as your 50 tons. The key moment is the act of identification.
And this process of identifying the goods is called ascertainment or appropriation. It's the action of taking the general pile and setting aside the specific bit for the buyer. A perfect modern example is an Amazon warehouse. When you order a book, it's just one of thousands on a shelf. It's unascertained. The moment a worker picks that specific copy, scans it, and puts it in a box with your name on it, that is appropriation. And at that point, ownership and the risk has very likely just passed to you.
Now, up until this point, we've been working on one giant assumption, that the seller actually owns the thing they're selling. But what if they don't? This brings us to a whole other legal principle, a kind of plot twist that deals with the tough situation when two innocent people get caught in the middle.
And here it is, our second big Latin phrase for the day. Nemo dat quod non habet. Just like the first one, it packs a massive legal punch. And it's a fundamental pillar of how we think about property.
And the translation is simple and direct. You cannot give what you do not have. The general rule is, if a seller doesn't actually own the goods, they can't transfer ownership to a buyer. So if a thief steals my laptop and sells it to you, even if you paid a fair price and had no clue it was stolen, you don't get good ownership. I'm still the true owner, and I can get it back from you. This rule is there to protect the basic security of owning things.
But, and this is a huge but, imagine the chaos if that rule was the end of the story. Business would just stop. Every time you bought something, you'd have to do a full background check on it. So, to prevent that, the law created a whole series of really important exceptions, designed to protect innocent buyers in certain situations and to keep commerce moving.
As you can see from this flowchart, even though the Nemo dat rule is our starting point, there are a bunch of different pathways where someone who isn't the owner can actually pass on good, legal title to an innocent buyer. This is where the law is doing a very tricky balancing act between protecting the original owner and protecting regular business deals.
And here are the main exceptions. For example, sale under avoidable contract. Let's say a con artist tricks someone into selling a valuable watch for way too little. The con artist's ownership is voidable. If that con artist then sells the watch to you, an innocent buyer, before the original owner realizes what happened, you get to keep the watch. Your good title is protected. Another is estoppel, where the true owner does something that makes you believe the seller has the right to sell. The law basically says, hey, you helped create this mess, so the innocent buyer shouldn't pay the price.
Okay,